Hi, good afternoon, everyone. Thanks for hanging with us for a little bit of a temporary technology issue. My name is Jessi Thaller-Moran. I'm an attorney in the Brooks Pierce Raleigh office that practices labor and employment law. And I'm here with my colleague, Tricia Goodson. We are very excited today to talk to you about something that is not COVID related. We're going to be talking about some of the new challenges we see for employers who are hiring in an increasingly remote world, and specifically across state or perhaps even country lines. There will be a SHRM code at the end of the presentation, so stay tuned if you are here for that. And as with the other webinars, if you have questions at any point in the presentation, please feel free to submit them in the chat box, which should be at the bottom of your screen, and we will integrate those into the presentation as we can. So as I mentioned, my name is Jessi Thaller-Moran. I practice out of our Raleigh office, and I'm actually working remote today, which is very appropriate for our presentation. And I'll let Tricia introduce herself.
Hi, everyone. Tricia Goodson, and I likewise practice out of our Raleigh office, but today I have the virtual background of our lobby, but I'm actually working remote today as well.
So we are living what we are discussing. If you've joined these webinars in the past, you know we always provide this disclaimer, and I think it's particularly important today. A lot of what we're going to be talking about is going to be very fact specific and dependent on the applicable state or city or country with which you're working in the employment context. So this webinar is provided for general information purposes. Please don't consider this to be legal advice or use it as a substitution for consulting an attorney. All right, so here is my cheesy little illustration of the work circumstance that a lot of us are finding ourselves in, particularly with regard to employees with desk jobs after the past year. You know, here you've got someone who's sitting outside, someone who's possibly in a different time zone altogether, someone who's in a more conventional office setting. They could very well all be in the same meeting at the same time. So as we see this being a trend that is likely around for the long haul, you know, if you look at surveys of the workforce, a lot of people like remote work, want to continue that in to some degree. And employers are turning around and saying, well, maybe we can cast our talent net a little bit wider if we're not confined to this specific office. So what does that mean from a legal standpoint? And like any good lawyer, my first answer is, it depends. But I think generally speaking, it's a good possibility that the jurisdiction from which you are managing that employment relationship, or if you're vetting a candidate during the hiring process, wherever that office is from which you are doing those things, and the place from which that employee is primarily working, or where that candidate is sitting as they apply for that job, they'll probably both lay claim to governing that relationship. And so it may end up being a lot of risk weighing with your legal counsel, depending on where that person is and what the particular position is in terms of evaluating what each jurisdiction requires, what are the penalties for violating a requirement if you do, and then thinking about how you can structure your workplace policies so that they are as neutral in applicability as possible, so that you're not having to reinvent the wheel with every new person you bring on board. Okay, Tricia told me I got this slide because the pop culture reference spoke to me, and I wasn't sure if it didn't strike a bell for her. There was a game show in the 90s called Where in the World is Carmen Sandiego? And she was somewhere in the world and she was doing something nefarious, like stealing the Eiffel Tower. And the people on the game show had to figure out where she was based on these context clues. So in my mind, as I now sing that theme song in my head, I'm thinking, where in the world is your employee? And do you need to know? This is complicated by this new trend we're seeing in what I'll call the Airstream lifestyle, right? Some folks who have gone remote on a permanent basis say, I don't really need a brick and mortar home. I'd rather live in an RV or hop between Airbnbs. What do you do with someone who's either completely transient or has sort of set up two domiciles? And the example I'll give is like someone I know who works in DC, but spends probably half of her time in Oklahoma right now. That's a pretty even split in two jurisdictions that have very different employment laws. So what do you do as the employer in a situation like that? And again, it's going to be very fact specific and depend on the laws that touch that relationship. This is new territory. We really don't have great guidance on this right now. But I think as a general prospect, it's a good idea as you're vetting candidates, as you're bringing folks on to work, to figure out where are they applying from, where do they primarily intend to do that work, and then where do they claim as their residence. I think those are the three factors that are most likely to inform how you conduct that analysis. And Tricia and I were talking about this yesterday and how employers might incorporate this into their policies going forward. And I think it might look something like modifying your remote work policy to say that approval to work remotely is contingent on notifying the employer where you'll be working. Or to the extent you already have a policy that requires employees to keep their personnel files up to date, perhaps that includes providing information about where they'll be working. So these are just some ideas to think about how you can stay as informed as possible about where they're working. And I'll pause here to say, we're not suggesting that if someone goes on a 5-day vacation to California, that California law suddenly applies, right? We're thinking about where is there going to be a substantial connection between where the person is performing that work and where they're located. And we're thinking about this in terms of the entire employment cycle. So all the way from the very beginning, do you even have an employment relationship? Do you have a contractor that some jurisdiction would deem to be an employee? All the way through the hiring and recruitment process, what do you need to tell them about pay, drug testing, background checks, keeping them safe in the workplace from discrimination and physical dangers, and then all the way through termination and enforcing those post-restrictive covenants. So these state-specific laws really are going to inform the entire life cycle of the employment relationship. And with that, I'm going to turn things over to Tricia.
Okay, so as Jessi was saying, we're kind of going through the life cycle, and we start with, are you engaging an independent contractor or are you hiring an employee? And what you label it doesn't really matter. It's going to be very fact specific as to whether or not a person is an employee or an independent contractor. And then it gets even more complicated by the location of where that person will be performing the work. So it's really a very fact specific question that's going to be governed by local law or state law. It's not all things are equal. Some states are very employer friendly when it comes to this analysis. Some states are really clamping down on misclassifying contractor relationships and saying somebody's an independent contractor when they're an employee. I think we're all aware that there are lots of federal laws. I mean, the IRS really cares if you're misclassifying somebody because they are losing out on some taxes. So we know there are federal laws, but there are likewise some state laws. And just to give an example of some states that are moving towards maybe a more restrictive approach or a more skeptical approach would be Colorado. They have a presumption that the person's going to be an employee unless you can show that they are free from control and direction of the performance of services, that they're under contract, and in fact, actually not under your control, and that the individual is customarily engaging in independent trade. So like a key thing in Colorado that you may not know, lots of you may have independent contractor agreements. In Colorado, in order for that agreement to help you with the presumption that they're not an employee, you have to have a paragraph about you don't get unemployment, you have to pay your own taxes. That paragraph has to either be larger type or in bold. So that's just a little nuance for Colorado that probably doesn't exist in a lot of other states. And all of a sudden, you may lose out on the classification because you forgot to bold a paragraph or you didn't know you had to bold a paragraph. So I'm using this as an example just to show you the importance of really knowing what the laws of the states are in which you have employees or you're engaging people to work. California is another one. And of course, California can be its own beast on all things employment. Sometimes I think that if you can comply with California, you're probably good most places, but they likewise have, a set test that they look at for engaging independent contractors. And even in North Carolina, they have ramped up enforcement of the improper classification. We've got the North Carolina Industrial Commission Criminal Investigations and Employee Classification Commissions. We've got internal North Carolina agencies that have memorandums of understanding so that they'll communicate with each other, whether it's workers' comp, industrial commission, or for unemployment. So, and they each have their own test as to how somebody's defined as an independent contractor. So it's really important to know that, because penalties for misclassification can be steep. And again, just because you and the person agree that they're going to be an independent contractor, the government doesn't really care. That is not going to be a determining factor. Another area that is really varying from state to state, and the first is salary history bans. Over the last several years, numerous states and local governments across the United States have enacted the salary history ban. And the rationale for a lot of these is the aim is salary history, eliminating it is to increase pay equity. So essentially it eliminates the wage gap for women and minorities, because if you're asking up front, what did you make? And, a female or a minority was making less than a male, you might be apt to just give them what they were making or just a little bit more, where a male, you might pay them more. And so that just continues this inequity in pay. So that's essentially the rationale. But all the states and some local governments are handling it differently. And you have to know, and this is going to be applicable if the person is going to be remote, that you're hiring somebody to work in, for example, Alabama or New York, or if you're hiring them to come work, physically in North Carolina, but they're located in New York right now. And so you are engaging in the hiring process with them while they live in New York and they're physically located there, then that law is going to apply during the hiring process. So some states or locals, they have an inquiry ban, and generally these laws are going to ban employers and recruiters from asking an applicant about their current or past salary, which could include bonuses, benefits, and other types of pay. Then there's also, in some of these laws, a reliance ban, and that typically prohibits the employers from relying on an applicant's wage history to determine whether to hire the person or what their salary may be. And then there's, in some states, even a retaliation ban, which it prohibits you from retaliating against an applicant that refuses to reveal their salary history. Most of these laws also address what happens when it's an unprompted voluntary disclosure. Some say, you still can't use that information. Some of these laws say you can. They also might address what happens when it's publicly available information. Maybe you're hiring somebody that was at a publicly traded company and it's part of their reporting. So bottom line is, it is all over the states now, not in all 50 states, but all over various jurisdictions. So Hawaii, Puerto Rico, Vermont, Massachusetts, Connecticut. You've got some local places like New York City has their own. In California, I think San Francisco has it. So just because a state may not have it, the city may. So you really need to know what the law is when you are interviewing applicants because of the geographical considerations. You don't want to get in trouble from the beginning. And then we've got the fun pay transparency requirements. And these are emerging, it's an emerging trend. And again, the trend seems to require these pay disclosures at a minimum on request, but there are some proactive disclosures. I think that the push for pay equity is what is pushing this pay transparency requirements as well. because then you're being upfront what you as an employer are saying that the pay is going to be, and you're not going to be basing it on the applicant's pay history at that point. So again, this varies from state to state. I would think I'm going to talk about Colorado because I think it has one of the more interesting, they've got, well, I say interesting, but also probably the more burdensome requirements. They're an employer with even one employee in Colorado that's recruiting for a job in Colorado or a remote job that could be done in Colorado. You have to include the wage rate or range for the role, a general description of other compensation available for the role, and a general description of benefits for the role in the job posting. So you can't, it's not something that upon request you would give it. This has to be in the job posting. The other thing Colorado is requiring is opportunity transparency. And this is saying that employers with at least one Colorado employee must also provide written notice to the Colorado employees of any promotional opportunity, including any hire, change in job title, or material change in job duties, opportunities, or responsibility before it decides who will get that new job. So, I mean, even employees who are not qualified for the job may have to receive the notice of the opportunity. And there are all sorts of exceptions, and we could probably do a whole webinar on Colorado's law. But the point is, you've got to know what the state laws are so that you can comply with them. Because if you didn't know that Colorado had these and you have at least one Colorado employee, you could be in violation of the law. There are others like Nevada, Connecticut, California, Maryland, Rhode Island, Washington. They all have some sort of pay transparency requirements. And I think I saw in the chat, so I'm going to pull it up, a question. If a state requires pay transparency in postings, if a person applies who lives in that state and the role was not specifically posted to be based in that state, is reposting of the role within that information required if we're considering hiring someone from that state? Again, it's so state specific law-wise that you would have to, like in this hypothetical, we'd have to know, well, what state are you talking about? If the role could be done remote, again, in Colorado, they're going to say, well, our law applies because it theoretically could be done in Colorado. But the Colorado law does have exceptions. If this is a job posting for something that can only be performed in another state, then they're not expecting you to post this information on the job posting. But I certainly, if you've got a, so I think the key for Colorado, for example, was the job has to be able to be performed there. If somebody who just happens to live there is thinking about moving to North Carolina and applies for a North Carolina job posting, I don't think that Colorado law would apply. But I would say if you've got a candidate that lives in another state for remote and you didn't put this, you may want to quickly look at what that state's requirements are so that you can make sure that you are in compliance. And if you're not in compliance, I think you could post after the fact, but at least it would show you were attempting to comply.
Tricia, this is making me think that these kinds of laws are ripe for consideration or a challenge in the courts, because what it amounts to is Colorado regulating employers across the country, because anyone in any 50 state could apply for that job. So it'll be interesting to see how courts handle these laws over the next few years.
Right. And I also wonder, what jurisdiction does Colorado have? If you're an employer and you're not doing business in Colorado, I'm not really sure how Colorado can reach out and grab you anyway, because you're not doing business in Colorado. But this is the new twist with remote working, is that maybe all of a sudden you are doing business in Colorado. You never have been before. Or let's say you have an employee who was always in North Carolina. During COVID, y'all have gone remote. Now you're allowing people to work remote. And unbeknownst to you, your employee moved to Colorado. So now Colorado law, according to this one law, you've got one employee in Colorado. So I think that goes back to what Jessi said of really making sure your employees understand they have an obligation to tell you if they are working, if they've changed their work location. And again, I'm not on a long weekend basis, or I'm going to work remote from the beach to this week, but there are some that have moved. And I've heard this from multiple employers where they had employees move during COVID and they had no idea that the employee moved. They just didn't tell them because they didn't want to be told, well, you can't work from there. So they just didn't tell them. So I do think you're going to have that. All right. And then another, let's see, background checks is another one that I think is with the multi-state hiring, remote hiring, et cetera, background checks. This is another one area where states really vary widely on the laws here. So the employee's location can affect the required disclosures or permission an employer must secure prior to running a background check. You might have heard of ban the box. The EEOC for years has said, we're going to ban the box, and they felt like asking questions about prior criminal convictions could have a disparate impact on people. So they were encouraging or requiring that it not occur up front and that it have a reasonable relationship with the job. And now there are multiple states that are also agreeing with this. So you might hear ban the box. You might also hear it referred to as fair chance laws. But fair chance hiring practices, they're really designed to give ex-offenders a better chance of getting jobs. And it is gaining ground nationwide. It prohibits conducting criminal history inquiries until, when I say this is kind of overarching, but again, it would be very state specific, but we're seeing a trend where the ban the box laws would prohibit conducting criminal history inquiries until a conditional job offer is made, among other requirements. And that's, again, to let the candidate come in, make an impression on you before you find out that maybe they have a criminal history. Then some of these laws go on further, and it's not just dictating the timing of when you make the inquiry, but it's also dictating how you can consider that information. There may be a time frame by which how far back you can go, the types of criminal convictions, the relationship to the job that you're looking at hiring. So all of these are things that you're going to be seeing in these background check ban the box laws. So an example of one would be Illinois just recently did one. And one of the things that it requires is that you have to establish a nexus between the conviction and the job or demonstrate a real risk. So you have to look at like the length of time since the conviction, the number of convictions that appear on the record, the nature and severity, facts and circumstances surrounding the conviction, the age of the employee at the time of the conviction, and evidence of rehabilitation efforts. So Illinois is requiring you to do all that. And then you have to send notification of an adverse preliminary decision, which is similar to the Federal Fair Credit Reporting Act. You have to provide an opportunity for the applicant to respond. And then you can make a final decision and provide notice of that final decision if it's an adverse action. But keep in mind, it's not just state. San Francisco has a local ordinance. Los Angeles has a local ordinance. New York City, for example, has another local ordinance. So you have to look at state and local, which does make it overwhelming for employers. And so some of y'all might walk away from today thinking, I'm so overwhelmed. And it is hard when you are a multi-state employer and or if you are considering hiring people remote. I believe there's some that, and I've heard this, I haven't seen an ad or a posting, but I've heard that some employers are saying this posting is not eligible for anybody that lives in Colorado. because they don't want to deal with Colorado law. And so they're just saying nobody from Colorado is eligible for this posting. It makes it pretty clear. Then you're not going to become an employer in Colorado. So I think then we can move on to the next fun topic, Jessi.
Yeah, I'm going to touch on drug testing, which is a hot topic right now, particularly with the increase in legalization of marijuana in many states, including our neighbor just to the north, Virginia. So I'm going to specifically touch on marijuana in a minute, but I do want to start with drug testing. Those of you on here who are employers are probably familiar with the fact that we have had for a long time some federal guidance from the EEOC about making sure that you're not, much like with Ban the Box, applying your drug testing policies in a way that disproportionately excludes certain groups of candidates. What we've seen state by state is contours to drug testing programs that employers have to follow in terms of what's in their written policy and how they administer that testing. So North Carolina is actually a pretty good example of this. And I've got it lumped here into pre-employment and during employment, but in general, you want to pay attention to when you can administer that test. Can you administer it during the recruiting and hiring process? Do they have to have a conditional offer? Does it have to be following a workplace accident? Can you do random drug testing? Do you have to have reasonable suspicion? All of those things are going to be set out in state laws. What disclosures does a candidate or an employee have to have? Typically, you're required to have a written policy that gives the employee or candidate notice of how you will drug test, under what circumstances you'll drug test, and what the possible consequences could be for a positive test. So again, that's something that's going to be very fact specific. Are there certain jobs for which you are required to test or for which they are the only positions you can test? Do you have to be operating a motor vehicle or some kind of heavy machinery to be subject to random drug testing in that state? And then the last piece I'll touch on is the format of the drug test. We've got a lot of companies out there who will offer to mail you an in-home drug test. I know for a lot of employers, it's very tempting to say, hey, we can just keep these in the office. And if someone comes to work acting a little bit funny, we can just administer it here in-house. There are state laws that dictate what the test format can be. So is it saliva? Is it some other bodily fluid collection? How should it be collected? Are you required to observe the person providing the sample? Or conversely, are you required to give them privacy while they provide the sample? How can it be tested? What kind of lab needs to process the results? And then even if that test is permissible under state law, you still have these questions of whether the administration of the test and the maintenance of the results will preserve that evidence in a way that it backs up your subsequent employment decision. So on that note specifically, I would just advise you to, or I would suggest in an informational sense that you exercise caution in using these mail order drug tests. But all of these things are going to be very heavily guided by local state laws, and you want to make sure that you have a written policy that complies with the applicable laws. The last piece I'll add on drug testing, which segues a little bit into marijuana in particular, is that because the EEOC has been concerned historically with a disparate impact in terms of how it's applied, you'll want to be cognizant of not varying the policies between states, except to the extent you need to comply with state law. Because what you don't want is to set up a situation where someone says, well, I was treated differently based on my positive drug test for something other than geography. So treat everyone this as similarly as you can under applicable laws. And again, that segues to marijuana use. Again, Virginia just legalized recreational and medicinal marijuana effective, I think, July 1st. Tricia will touch on this more later in the presentation, but there is legislation moving very slowly through North Carolina's General Assembly that might legalize marijuana to some extent. In the employment context, this is complicated by the fact that we don't currently have real-time testing available, right? So unlike an alcohol test, like a BAC, where it's more or less contemporaneous, someone could trigger a positive result for marijuana use that happened days before, and it could be legal in the state to to imbibe on your free time, but that doesn't mean you have to accommodate it in the workplace. So some states like New Hampshire, Pennsylvania, Virginia have specifically said in their laws, well, it's legal, but employers don't have to accommodate marijuana use in the workplace. I think Virginia has said something like, you don't have to accommodate employees coming to work under the influence. And the question then becomes, how do you confirm that they're under the influence when you can't test for what's currently in their body at that time? So it's a little bit murky. And I think what we're seeing is kind of a patchwork of state laws passed that the legislators are then coming back to kind of clarify things or clean things up. And I think whatever company comes up with a real-time test that's reasonably affordable first is going to make big bucks.
Yeah. And Jessi, I'm going to jump in. We're also seeing employers right now, they're having such a difficult time hiring people just because there aren't enough people to work right now or willing to work. And marijuana tests are, they're, having a lot of positive marijuana tests that under the way they've always done business would preclude their employment. And now employers are wondering, well, do we have to just maybe not test for marijuana? I mean, so that is something else, like another dynamic I think employers are dealing with.
For sure. The last piece I'll add on the medical marijuana piece is that if you are in a place where the local law allows you to prohibit marijuana use and you want to do that, someone who comes forward with medical marijuana justification should be a little red flag for you to consult with your counsel on an ADA reasonable accommodation analysis. So it may be that the marijuana use is not a reasonable accommodation, but there might be another accommodation that would be considered reasonable under the law. So to the extent you end up kind of butting heads with a situation like that, that is a place to pick up the phone and call your attorney. Workplace safety, I'm just going to touch on this at a very high level. To the extent you have folks working across state lines, different states have different requirements for workers' compensation. What format has to be maintained, what's the threshold required, what are the requirements in terms of reporting injuries, coverage, that kind of thing. OSHA plans, North Carolina's OSHA more or less just adopts the federal OSHA standards and scheme, but that's not the case in every state. So that's something to be aware of. And if you've been to any of our webinars in the past year, as we've talked about remote work, as it kind of evolves under this weird new world we live in, we've touched on the fact that even an injury that occurs in a quote home office may trigger a compensable injury under your workers' compensation plan. So that's something to be aware of. And we'll talk about this more later on, but this is why it's important to keep those lines of communication open with remote employees and encourage them to notify you of anything like that as it arises.
Well, and I'm going to sneak in a little COVID here, even though we said this wasn't going to be about COVID, but a lot of states are issuing COVID safety kind of guidelines. And so what may be okay in one state from a safety COVID guidelines may not be in another. So that is something right now. Let's see. Oh, I even jumped the gun for Jessi.
But you did a great job. That was what was coming next. Yeah, but so like Tricia was saying, it is very state and even local specific. COVID is interesting. COVID's not interesting. We're tired of COVID. COVID workplace safety is interesting when a lot of what we're talking about here is someone working from a home office. So some of these concerns about things like masking may not be as applicable, but like vaccination and specifically workplace vaccination requirements or vaccination inquiries, that's a place we are seeing a lot of divergence among different states and cities. So like Montana has passed this law that says it's illegal to discriminate against a person in the employment context based on vaccination status. I'm not really clear on how that's going to pan out in terms of application, but they've gone for it and they've passed that law. On the other hand, you have states like Oregon that have said, if you're going to permit an employee to have certain privileges in the workplace, like going maskless, you need to confirm their vaccination status. And then you layer on top of that, this trend in laws where there are limitations on whether and how you can obtain information about an employee's vaccination status. So most states that have passed vaccine inquiry bans, like Florida, have specifically decided not to include employment in the employment context. I think they recognize that employers might have a special need to confirm their employees' vaccination status. But like in Georgia and I think Idaho, there are restrictions on learning that information from that employee versus learning it from like a state agency. And I think the concern is that there would become some kind of centralized database with vaccine information. So this is very much moving. I mean, like week to week, we're seeing trends moving in this realm. So this is, again, just something to be aware of. And to the extent that you do have a workplace vaccine mandate, you know, you need to think about how that's construed and drafted in a way that applies or doesn't apply to your remote employees. So we just got a question. Federal OSHA has indicated they will not hold employers accountable for inquiring about COVID illness or vaccine. So like Montana, will federal OSHA stand and protect employer for asking? So in general, they do butt heads on occasion, but in general, the federal standard is considered kind of the floor, and states are free to pass higher restrictions. I think what you're identifying in this question is the tension we're seeing with regard to a lot of COVID protocols, which is what you do when you have, on the one hand, clear OSHA guidance that says you need to provide a safe workplace. And one of the ways you do that is finding out who's vaccinated in the workplace. And then you have, on the other hand, this more local law or regulation that says you can't collect that information. And that's just some tension right now that employers are juggling. We don't have a clear answer yet. It really hasn't been vetted by the courts. But you do have a very clear obligation to provide a safe workplace. So to me, that kind of underpins any analysis that happens in this department. Tricia, I don't know if you have anything to add there.
No, not really. I think you covered it.
And every employer is banging their head on the desk going, no matter where you turn with regard to COVID stuff, there's just not a right answer. So I'll touch on compensation. We're moving away from COVID again. And just flag for you that there are some state and local laws that have more stringent compensation requirements than at the federal level. So North Carolina obviously mirrors the federal minimum wage and overtime requirements with our wage and hour law. There are localities or states that have higher minimum wage requirements. And I'll pause there to say, to the extent you have an employee, particularly working remotely, who you believe is exempt from minimum wage and overtime, if you have not touched base with your counsel about this in a while, it's probably a good idea to do that. A lot of employers have employees that are paid on a salaried basis and treated as exempt who are not actually exempt under federal wage and hour law. So, but assuming that they are eligible for minimum wage, they need to make the relevant minimum wage for the jurisdiction that applies. Overtime is occasionally calculated or defined differently. So like California, again, California is its own special place. You can collect overtime in California if you work over 8 hours in one day. So it's not dependent on crossing that 40-hour threshold for the week. It's a day-to-day basis. So again, just an example. And then timing and method of payments. A lot of employers are moving almost primarily, if not entirely, to direct deposit. And that may or may not be the exclusive method of payment permitted under applicable law. You may be required to offer a paper check or a prepaid debit card as an alternative. And then, how regularly does payday have to occur? All of that fun stuff. Meals and rest periods. A lot of states have mandatory rest periods or meal breaks. Sometimes they have to be paid, so just be aware of that. Wage deductions. If we or your counsel has worked with you on wage deductions in North Carolina, North Carolina is a place where we're actually more finicky about wage deductions. So making sure you understand what kinds of deductions you can do, what authorization needs to be on file. Does it need to be signed by the employee? Do they need the opportunity to revoke the authorization before you make that deduction? And then I'll say with regard to final paychecks, a lot of times we have employers asking about withholding part or all of a final paycheck because of broken equipment, stolen equipment, something like that. And in general, you want to be really cautious about proceeding below minimum wage to the extent that deduction is permitted at all. So that's always a place you need to check on the local law before you proceed with a deduction. And then payment upon termination. Tricia will touch on this in North Carolina in particular, but make sure you know how soon wages need to be paid at termination of employment, and what happens to that accrued but unused PTO. Tricia, I am going to pass it over to you. I see there's a question, but I think it might take me a minute to read it.
Okay. All right, so the next one is workplace policies. And that could include your handbook, just your general workplace policies that you may have. And again, it can be impacted by the state and local law. So for example, you could have the state equivalent of an FMLA, and it could have a different applicability to your company. Maybe it's fewer employees and you're still applicable to it, or maybe it's a lengthier family medical paid leave. Maybe the state requires a certain amount of paid sick leave to be done in their state. Of course, may not be in other states, like North Carolina doesn't require employers to have like a paid sick leave, but other states might. So you have to look as you're preparing your policies and know that some states may differ. And so that is really tricky. How do you handle that in a handbook? Do you have to have a handbook for each state, or do you maybe do an addendum? And I think some of that is going to be impacted greatly by where you're located and how many states are involved and how complicated it gets. So I think it is something you just kind of have to brainstorm with counsel about how can you handle that. Some other examples could be some states require jury duty pay. Some states don't. Access to personnel files. Some states say that's the employer's property and you can do with what you want with personnel files. Some states say employees have the right to look at any documents that they've signed, or maybe they have complete right to look at their personnel file. So again, if you had an employee request to see a personnel file, my first question to clients is, well, what state are they in? Because and then what's your policy and what state are they in? Because we need to see if we're complying with the law. And, vacation pay, wage deductions, all of those things, some of those are compensation that Jessi's already talked about. They are tricky, and you have to know where you're located and where your employees are working. Because again, that goes back to remote work. You might hire somebody, and for the first time ever, you've got somebody in Alabama that you've never had to deal with Alabama laws before. Then the next area is anti-discrimination laws. And again, I'm just going to briefly point out that there has been a lot of recent activity in this area at state and local levels. They might extend, the state and local levels might extend protection beyond what the federal laws have required, or have a lower threshold of applicability, where the federal might be 15 employees, a state may be 3 employees. So you need to be aware of what the state and local laws. Another example could be dress codes, and being aware of gender specific requirements or hairstyle expectations that could be read to target certain genders or ethnicities. For example, New York City prohibits discrimination based on natural hairstyles. So you just have to be careful as you might not think your dress code has anything to do with discrimination laws, but if it is very gender specific, it very well could be in violation of the laws. And then the next thing we just briefly touch on is the state and local laws regarding time off. So when you're having a PTO or a vacation policy, sick leave, for example, in North Carolina, you don't have to grant paid time off. But if you do, as an employer, you have to be clear about when it's forfeited. So if you're going to say it's a use it or lose it policy, and at the end of the year, it doesn't carry over, you need to specify that in North Carolina. At the end of employment, do you get paid out for unused vacation? In North Carolina, if your policy's silent on that, then that is deemed to have been earned and you would have to pay it out. So it is very important when you're having your time off policies that you're clear on what those state and local laws are, and that you craft it so that you're in compliance, but also hopefully being able to do it the way you intend for it to be, which is if it's forfeiture, that you are putting yourself in the best position to say, nope, you don't get paid out for accrued but unused vacation. Same with sick leave. You want to make sure you're in compliance. Like I said, some states may require some paid sick leave, others do not. And we're slipping in COVID again, but there are some states, local laws that might have COVID leave right now. So you need to be aware of that. And then leave for specific occasions, whether it's paid or not. I already mentioned jury duty. Some states or local laws might have paid time off, or at least just protection for those that are seeking leave for domestic violence, visiting or volunteering at a child's school. I think in North Carolina, ours is up to 4 hours that they could have protected. It doesn't have to be paid, but protected leave. And then, of course, you've got military related reasons that could be state specific as well. So you want to make sure you're looking at all those types of leave laws in the state and local levels and that you're aware of them. Another area to be aware of is restrictive covenants. And enforceability of these are so fact specific and jurisdictional. What law applies? So a lot of times employers will have a choice of law provision, like we're going to apply North Carolina law no matter where our employee is located. In some states, they'll apply North Carolina. Some states will say, nope, we're going with our law. For example, if it violates the law of the state where the employee is located, where you're trying to enforce the document, they may say, well, we're not going to apply North Carolina's law because that violates our public policy. California is probably the most unfriendly to non-competes. And so they are not going to want to apply North Carolina law. So just keep that in mind as you're preparing restrictive covenants, that each state has very different laws. So consideration, continued employment might be consideration in some states, and in other states it will not be consideration. And the acceptable length, the acceptable geographic territory, all of that could be differ widely from different states. Another issue, and we're kind of breezing through these at the end, but we want to make sure we get to some of these questions, is mini Cobra. We know that there's a federal Cobra law, but there are some state Cobra laws as well. When you're not covered by the federal, the state may have different laws. So you would want to make sure you're complying with those state laws, especially if you're, as an employer, you're not subject to federal laws for the Cobra. And then out of sight, but not out, tax obligations. Sorry, go back, that's fine. Jumped ahead. I hate taxes, so maybe this is why I just didn't want to talk about this one. This is a big one that you will want to make sure you are consulting tax counsel regarding the payment of applicable employment taxes. Do you tax them where the business is? Do you tax them where they're living? Oh, it's even trickier when somebody lives in New Jersey and they work in New York and then they're remote. I mean, it can be complicated, and you want to make sure you are doing it correctly. So you want to make sure that you, especially as you hire new remote workers, that you are withholding the proper state taxes. Now, the out of sight, but not out of mind. This is just a reminder that, workplace supervision still applies to remote employees. And you want to think through that policy. You might want to think through training for the supervisors who are now dealing with remote workers. And maybe they've never had to deal with remote workers before, and they don't know how to supervise them. But it's still your responsibility to ensure that time is recorded and compensated accurately. Just because somebody's working remotely, you still need them to be recording time if they're an hourly employee. And you have to pay them for all time worked. Workplace inclusivity, anti-harassment obligations, all those still apply in a remote world. So just because somebody's not physically in the office, don't make assumptions that they could never be harassed or discriminated against. You want to make sure your managers are still supervising competence and quality of work, and doing it fairly. You can't have somebody hold it against somebody that they're a remote worker. If that was something allowed by the company, you want to make sure that they're getting the same standards are held to the same standards. And then you want to make sure that performance feedback, quality of work, etc., is being applied. So I think this is just an area just to remind you that you might need to train your supervisors in how to do that with remote workers. And I think we've got, don't forget to check your own backyard. So, I mean, as we're talking about, you got to learn all these other states. North Carolina law is currently evolving as well. For example, North Carolina has a new wage and hour law that requires written notice of the amount in terms of wage payment to all employees and advance notice of at least one pay period before any changes. So that's a big change in the North Carolina law. I think previously it was maybe 24 hours notice of a pay change, and now it's one pay period. Now, they do make it clear if it's a raise or something to the employee's benefit, it doesn't have to be a one pay period, but anything that would be seen as negative or adverse has to be one pay period. As Jessi mentioned, we've got a very slow moving bill that's been proposed to legalize some kind of marijuana use in North Carolina. I think it's more focused on medical than recreational, but that is something is on the horizon. And then we've got local municipalities in North Carolina that have passed stricter EO laws like Durham and Asheville. So again, we're talking about all these other states, but North Carolina does change their laws from time to time as well. So it's a good reminder to stay abreast of all of that.
And we've got a couple questions in the chat box. Feel free to add yours in if you have some as well. I'll just touch on these first two. The first question comes from a healthcare provider who asks about an employee who comes into work smelling like marijuana. And I'm going to say for healthcare providers in particular, using North Carolina as an example, there are some affirmative obligations on employers to ensure that their employees are not under the influence at work, stricter than some other industries. And so the question here has a specific example, and the best I can say is it's going to be really dependent on the facts and on the regulations that apply to you as an employer. So that is a place that I would suggest consulting with counsel. The next question asks whether there's an overall, anywhere that's collected all of these requirements in one place. We know we've thrown a lot of information at you and you're probably all pulling your hair out and thinking, I'm only ever hiring someone to work in a brick and mortar in Wake County, North Carolina. The answer is there is information out there. I've saw a lot of it putting this PowerPoint together, but as with anything else you see on the internet, it's the internet. So I would just suggest you exercise caution to the extent you find a chart or a table that looks useful. I would perhaps do some due diligence and talk with your counsel beyond what you're seeing. Tricia, there's a question here about North Carolina personnel file rights. I don't know if you want to touch on that.
Sure. North Carolina does not have a specific law on that. So that's going to be then the company policy. But the second part of this, does a company policy on personnel files override state law? And I would say generally, no. I mean, if state law says that an employee has the right to view their personnel policy, a company policy that says it's private property and you don't get to see it, that's just probably going to be in violation of the law. So your policy would not trump a state law, but you could, if there is no state law or if the state law is very generic, you could probably have something that would either be more generous, that still complies with the law. Like if it says you can look at documents the employee signed, but you as an employer could say you can look at the whole personnel file. So you could be more generous than the state law, but you can override the state law in a negative way.
And I want to jump in here and say we're seeing a couple of questions in the chat that relate to specific folks' individual situations. And I'll just say again, unfortunately, all we're able to do today is give information and not specific legal advice. So to the extent you have questions about a specific scenario that applies to you or to your employee, that is a place to reach out to your legal counsel because we cannot extend legal advice during this presentation. We have a high level question. Tricia, I'd love your input on this one. If you grant someone permission to work remotely and then something changes in the state's laws or it otherwise becomes administratively burdensome to let them continue working remotely, can you revoke that permission?
And I would say, yeah, always state specific. You'd have to look at the law and we'd have to know the facts. But generically, I would say it probably depends on the arrangement you made with the employee too. So if you have an employment contract where you said they could do this, then maybe you've contracted yourself into an obligation. But if it's an employment at will arrangement and there's no state law prohibiting you from saying, okay, we don't want to do remote work, then like a lot of employment situations, you could probably end that relationship because it's becoming more cumbersome than you want to have administratively.
And I'm cognizant that we're at 1:27 p.m. And so I'm going to say that this is going to be recorded and we will distribute the link tomorrow, I believe, when it's available. But I don't want to eat up everybody's time. Tricia, I don't know if you want to make any last comments before I flip to the SHRM activity code.
No.
Okay. Well, I'll just say again, Tricia and I are always happy to talk with someone. If you want to reach out to us after the presentation with specific questions you'd like legal advice on, of course, we're more than happy to do that.
Thank you for attending today's presentation. We'll now end the webinar.